into the legal issues in this particular case, the factual issues in this particular case. But I think where Mr. Rogers just left off and where I'm about to begin really does underscore the difference of opinion. Because the state of Texas does absolutely find it unreasonable that a trained 5-year veteran of the Dallas Police Department could go into the wrong apartment and shoot an unarmed man who was doing absolutely nothing wrong in the chest. The state of Texas finds it absolutely unreasonable that a person could do something like that and just say, whoops, my bad, and then go on about her life however she chooses to do it. Yes, the state of Texas finds that premise to be unreasonable. In fact, we find that premise to be unjust and unacceptable and insulting. A 5-year trained police officer who, as a matter of her ability to perform her job effectively, is trained to observe and to orient and to maintain situational awareness. We're not talking about somebody who just walks around, every day doing whatever else. She was given a special job at the Dallas Police Department, a position, because her observation skills, her awareness skills were that good. That is not where you put the slackers or the sleepers. So yes, to accept the premise that she could just walk into somebody's home who was no threat to anybody, kill that person, and then walk away with, geez, I really messed up there, is absolutely unreasonable. And it's unacceptable on a human level. Now let me just talk to you about where we are legally in this case. The facts that are undisputed right now are that on September the 6th, 2018, here in our community of Dallas County, Texas, this defendant shot with her firearm Botham Jean, killing him. And by her own admission on the 911 call and in this courtroom, it was her intent at the moment she shot to kill him. Those are the elements of murder, proven beyond a reasonable doubt. And those elements and those facts are not in dispute. So that's a starting spot. This defendant has committed murder. All right? To that charge, she and her team asks for you to give her the justification of self-defense. She has claimed that she was acting in self-defense at the time that she shot Mr. Jean. And Mr. Fine did a fine job going over all of the requirements that a person has to have in order to have the benefit of self-defense. Because I'm here to tell you, as a state's attorney, there are times when you have to use self-defense righteously and reasonably to save your life. And that's fine. That's why it's there. This is not one of those cases. And I'm just going to, and Mr. Fine put all of the elements up there for you. I'm just going to talk to you about two. Because she would have to have all of them in order to benefit from that justification. I'm going to show you where she fails on the two most important. First, and understand the premise of where these are coming from, because you have to kind of understand the background to appreciate why these words need to be given the meaning that they deserve. The premise is the sanctity of life is paramount. Life matters. If there's a reasonable alternative to taking somebody's life, then you are not going to benefit from the defense of self-defense, ever. And rightfully so. That is an option that the legislature has given us as a last resort when there are no other options. And why would it be any less? Why would we want to kill another human being when we could have done anything else? Right? So let's just talk about a couple of things that are required. Number one, in order for this defendant to benefit from self-defense, her decision to use deadly force must have been immediately necessary. And those are the words, ladies and gentlemen, that I need you to hear and give those words effect. When the legislature said immediately necessary, when we in our community have adopted this, those words mean something. Immediately means now, this second, at this moment. God bless you. That's what immediately means. It doesn't mean in a few seconds or a few minutes or if this should happen or if that should happen. It means right here, right now, I have to act. Nothing less. Necessary. Necessary means that you have to do it. There's no other choice. If you have a couple of different options that you could reasonably do, then killing somebody is not necessary. And unless you have the confluence of those two doctrines where it is immediate and necessary, you do not get to kill somebody and say, whoops, too bad, I'm going on with my life. So let's just talk about this concept first. What are the actual facts of this particular case when it comes to her decision to use deadly force and whether that was immediately necessary? We've long suspected her decision to use deadly force was made in the hallway. We've long suspected that because the keys were left inside the lock, which were indicative of her pulling her gun. She needed that right hand. And obviously, if she had a free right hand and she really believed this was her apartment, she would have taken out her keys as she was going in. Well, the trial confirmed that. Because not only on her direct examination, but on cross-examination, I made it very clear to go over this with her 2 or 3 times. She was in a position of safety behind a steel door in the hallway when she says that she made the connection between the fact that her door wasn't locked, it was ajar, and that she heard somebody on the inside. She was outside the door. She knew there was someone inside what she thought was an intruder. In fact, it was actually Mr. Jean doing absolutely nothing wrong. But she had the advantage of knowing someone was inside, and she assumed it was an intruder. And she decided from outside, from that position of safety, that she was going to engage what she calls the threat. And she decides how she's going to do it is by pulling her gun, opening that door, and going in to engage him. Now, what does that mean? That means she had options. That means deadly force wasn't immediately necessary. By her own admission, she didn't have to even retreat. She could have just stayed in the position that she was if she wanted to. Mr. Shook brings up this thing about the radio, about how we're trying to talk about after the fact. No. I'm talking about right then and there. She had a police radio on her. She had her cell phone on her. From that position where she was safe, outside that door, she could have called for police and said, I have an intruder, apartment 1478, or whatever apartment she wanted to give. She could have called for anybody to have come. They could have treated that like a barricaded person. They could have contained it. They could have used loudspeakers. Probably Mr. Jean would be alive had she decided to take the less lethal option. But she didn't. Because in her mind, at that moment in time, she decided to go in and engage that intruder. Now let me illustrate one other point that I think is critically important. By its very nature, self-defense means you're acting defensively, right? Does that make sense? What does it sound like she's doing? She is in a position where she is safe and secure, where she has options that she could have called for help. But what does she decide to do instead? Staying out there, calling for backup, calling for help, maybe even taking a different position of additional safety was an option that she had that she decided not to do. She didn't decide to do any of those defensive things. She became the aggressor. That's not self-defense. She decides from outside that door, I'm going in, I'm advancing, I'm engaging, and I'm going to deal with that person inside. And she's already indicated how she's decided to deal with them. She has a whole belt full of tools. She chooses to go after the gun, which is the most deadly weapon that there exists out there. And she tells you that she's going to engage. And what she does as soon as that door is open, and Mr. Shook, I'm just going to beg you different. My recollection of the testimony was that she put the key in the door and it opened up slightly. And I stood there at that gate the other day and I indicated every single time, pushed it open a little bit, pushed it open a little bit. And I said, was it then that you heard this person inside? Yes. Then she indicated with the left arm she opened up the door fully and that she used the left arm to keep that door open. That she used her gear to help keep that door open. She must have done that because she had her gun in her right hand. She had already committed to a course of action. While she was in the hallway, the only thing that was going to be the difference of life or death for Mr. Jean was how long it took her to find him as soon as she got into that apartment. The second that that door was pushed open by her and that gun was out, she was scanning that room until she saw Mr. Jean. The light from the hallway. The hallways have these bright lights. Floods into the room, and she's scanning the room. And Mr. Jean, unfortunately for him, he made it easy. Not only is he getting up from a seated position, but he's also saying, hey, hey, and these are normal reactions. He's pointed himself out immediately to her. And as soon as she acquires him, she shoots. How do we know that? You heard the testimony of Joshua Brown. Joshua Brown talks about this exchange where he hears, hey, hey, hey. He says as soon as he heard, hey, 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 right after that, 2 gunshots. There was no long conversation like Mr. Shook indicated. As soon as Mr. Jean identified himself and she was able to acquire that target, she shot him. And if they had given you the suggestion that somehow it was too dark for Amber Guyger to see, ladies and gentlemen, she shot him dead in the heart. That's not a mistake shot. That's an aimed, well-executed shot. The second bullet goes slightly above where his head would have been had he been fully standing up and out the wall. She's tracking him up from the couch as he's getting up, and the second shot goes up a little bit high. She saw exactly what she was shooting at. She also had, outside in the hallway, additional options. She didn't just have to stay where she was. She could have taken a position behind that second set of fire doors. She could have repositioned herself down the other side of the hallway. She had a host of options that a reasonable person would have done. Not just a reasonable person, but also a trained police officer. One thing that Mr. Shook, although he wants to, and Mr. Rogers, they talked a lot about what Officer Blair said, but they forgot to mention Officer Blair also telling you and me that if he was outside his apartment or outside his home and he knew there was an intruder inside, he wouldn't go in. He would respect the sanctity of life. He would call for backup. He would have taken a position of cover and concealment. That's another police officer, another person who is trained like her, who would have been using common sense and reason and appreciating the value of life. For Amber Guyger, Mr. Jean was dead before that door ever opened. And that's just the simple truth. I want to talk to you about also a little bit about her departure from training. Mr. Rogers wants to say that you really can't factor in what her training requirements are because this wasn't a dispatched call. Repeatedly, Amber Guyger testified that she would resort to her training in her everyday life. She was off duty when she backed her truck in, but police officers do that because they want to be able to get out quickly. She resorts to her training in her common everyday life. She talks about how she keeps her right hand free in case she needs to draw for her weapon. She was off duty when she did that. Why then would she abandon training and orders that she has had that is gauged for her safety? When confronted with a person inside of a building, Dallas police officers, and you've got it, I encourage you to read it. Standard Operating Procedure 1509, I think, 15 or 1709. It says 4 different times. One time in all capital letters, do not go in. Call for backup, take a position of cover and concealment. This is for your safety and their safety. Only go in when the scene has been contained and backup has arrived. You know, you can't have it both ways. You can't say, I'm going to take advantage of my police training sometimes and not others. Keenan Blair would have taken advantage of his training and he wouldn't have gone in. Also, I want to talk to you a little bit about this idea about loud commands, because I think that's also indicative of where Amber Guyger's mindset was about that both of them was going to die. She didn't give loud commands. There were 5 to 10 witnesses that live within earshot of this particular apartment. All of these individuals indicate that from the hallway you can hear when people are speaking and moving. Not one single person ever heard her say, "Show me your hands." Not once, let alone twice. And they talk about the power of the state to bring anybody down that we want. They have the exact same power. There were 300 people at that apartment complex who were interviewed that had some, all, or no information to share. If there was any single person that heard, "Let me see your hands," they would have been in here. Not one person heard that because she didn't say it. Because again, the truth was she made the decision to kill from outside that door. And once she put into play, she executed that plan perfectly by entering that door and shooting Mr. Jean. Let me talk to you about the other aspect of self-defense that I think clearly evidence shows that she woefully fails. And that is that in order for you to be allowed to use self-defense or deadly force to kill somebody else, it has to be in response. It has to be for you protecting yourself against another person's use of deadly force against you. All right? It's not just a matter of that it's immediately necessary, but also it has to be to protect you from deadly force being projected on you. And I still, as I stand here right now, I wonder what the defense is suggesting both of them Jean did that constituted deadly force on Amber Guyger, that would have allowed her to use the justification of self-defense. There is no question, it is undisputed, he was unarmed. That man had no pockets. There was no place he could have even hidden something. That wasn't his way anyway. There's absolutely no dispute that she saw a weapon or saw something that she thought was a weapon. I mean, how many times have we heard from police, "Oh, he pulled his cell phone out and I thought it was a gun or something." There was none of that. All Mr. Jean did was get up from a seated position to see what the person was coming in. The only other reasonable alternative was him cowering down behind that wall that separates him from Amber Guyger. Getting up from a seated position or cowering down to avoid getting shot, there is no way that any reasonable person can interpret that kind of body position as being deadly force. There's just not. And if the defense wants to somehow suggest that him being bent over at an exceptionally deep angle, like this it would have to be, what was he going to do? He had an ironing board in front of him. In front of that, there was a 3-foot kitchen counter in between him and Amber Guyger. What was he going to be doing, leaping over like some sort of a ninja? There is absolutely nothing that Botham Jean did or that she could have even reasonably perceived that projected deadly force on her, against her. Having failed both of the most important parts of self-defense, she doesn't get it. She doesn't get it. And I understand, I'm going to actually agree with Mr. Rogers about something, about the effect of sympathy. Because, see, one of my concerns is that facts like that really matter, the fact that both of them couldn't have been any kind of a threat to her at all, I'm scared that you guys might just decide that that doesn't matter to you. Because, see, you got to be in a courtroom and look at her for 7 days. She got to get up here and talk to you. You know? Because of what she did, this is all I can bring in. Mr. Jean can't come into this courtroom and appeal to your sympathy or to your emotion. He's been reduced to a cardboard photograph. So I implore you, please, please use your common sense in how you interpret this law. Self-defense is an option of last resort. She killed him unreasonably and unjustifiably. And just because she wants to throw out that I did it in self-defense, I need y'all to critically apply the facts that you heard in this case before you give her that. Because again, the state of Texas proudly takes a position. This is not one of those things where you could just say, whoops, too bad for you, buddy, you're buried 6 feet under, I'm going on about my life. No. If they thought that I was ashamed of that position, I've never been more proud of a position I've ever taken. Killing this man was unnecessary and it was unreasonable. It was unreasonable from start to finish. She had options outside that door when she had no danger. Options that didn't involve any violence to anybody. She didn't want to use it because she wanted to engage him. And everything after that was just a mere formality. We have proven the offense of murder. We have proven that the justification of self-defense doesn't apply on at least 2 grounds, any one of which requires it to fail for her. Amber Guyger is guilty of murder, and the state is entitled to that verdict, because that is the just verdict. And it is unacceptable that there could be no consequence for all of her unreasonable acts and her unreasonable decisions that she made at that time. Now, the defense points out that in the charge, you have been given the reasonable mistake of fact. And Mr. Fine was very careful and he was very clear on how that applies as well. It is a reasonable belief standard. And thank you, Your Honor. And that reasonable belief standard is based upon not only what an ordinary and prudent person would do, but from her circumstances as a trained police officer. And it was unreasonable. Listen to just this partial list of everything to do with where she was. Okay, she missed the roof line. She missed the floor number placards that are on the elevator. She missed 16 or 17 apartment numbers going to her door. She missed decorative flower pots and different kinds of floor mats on the floor. Most importantly, and this is the one that just can't be overcome, there was no other floor mat like this in the entire building. This thing sticks out literally like a red thumb. You can't miss this. When I carry this around the room, in this gray room, kind of like the gray floor at that apartment complex, you can't miss this. And she walked up to it and stood on top of it. Now, maybe Guyger didn't allow that to process in, but that's not the standard. It's whether an ordinary, prudent person with that kind of training and observation skills, no reasonable person would have missed this. That's not all, though. She missed the smells. The different smells about the room and the hallway. She missed all the furniture. Look inside those apartments. Look inside. They're not furnished anything alike. And from her vantage point, she could see entirely in. She missed the artwork on the wall. She sticks her key in, and as it's going open, she saw that red light blinking. And she knows that means that the lock doesn't recognize the key. She recognized the door wasn't locked when she knew that she locked her own door. All of these things would have put a reasonable person, like Miss Rose, who testified, would have put a reasonable person on notice to take a second. Take just 1 second and think about what is going on and what everything is telling you that this is not right. And she just refused to do that. She didn't even consider the fact that maintenance would be inside. I mean, she was on notice that maintenance was coming by that particular week. Now, I understand it was late, but anybody who's lived in an apartment knows that that's a possibility. It may be a remote possibility, but you may have somebody from maintenance in your room with a burst pipe, a small fire. You just can't walk into an apartment and start shooting, especially when you know that there might be somebody like from the apartment complex that's inside there. And let's talk about the reasonableness again. What, as Jason said, what kind of burglar goes in, sits on a couch, and is watching television? Now, let me just move on to that because, well, and also don't forget, there's absolutely no signs of forced entry. And that goes to the Castle Doctrine. In this particular charge, yes, she's asking for the benefit of the law that protected Botham Jean. And that's just wrong, but it's there, and y'all get to consider it. But in that, there has to be forced entry of an occupied residence. That doesn't exist. There has to be evidence that he was trying to push her out. That doesn't exist. Or there has to be evidence that he was trying to kill her, rape her, or somehow assault her or rob her. None of that exists. None of that exists. And they question, how is it that we're so confident that Amber Guyger walked in and Botham Jean was sitting on the couch? It's because it is the only explanation that fully comports with the three sets of physical evidence that existed on the scene. Number one, the trajectory for the bullet that hit the wall. Number two, the scene context of what's going on right in that immediate area as far as the ice cream and such. And number three, the wound path that the medical examiner testified to. This is number one. This is the trajectory of the bullet that hit the wall. Look where it goes. It goes right in front of that center cushion of the couch. It goes right over the seats of this couch. This is the trajectory that both bullets were following because you know that they were rapid shots. There wasn't time for a quick movement. Number two, the scene context. The physical evidence from the scene context. They want to put a lot of emphasis on the spoon. Well, take a look at the top of the spoon. It's dirty. It's been used. Now, I don't know why Mr. Jean would have put the spoon up that way. Perhaps there was a big piece of ice cream that was in the way. But you can tell this is where he's sitting, and this is the reason why. Number one, you heard how much he wanted to enjoy this bowl of ice cream. I can tell you as a big guy, when I put ice cream in a bowl, it's not going to sit there unattended. That's just a fact. Number two, you've got on the couch, you've got the center cushion that's open, you've got pillows on the right, you've got a blanket on the left. Next to the ice cream, you've got your remote control, you've got your laptop computer, and you've got your cell phone. Everything that he could possibly want is right there. That ottoman, when Officer Blair and Lee walk into the apartment, it's pulled up right to that center area as well. This was his nest. This was what he was doing. And when you asked the third piece of physical evidence, when Dr. Gwynn was on the stand and he was testifying about the trajectory, he said, absolutely. The bullet path that I found in the body is consistent with a person getting up from a seated position. And it absolutely is. For Botham Jean, who was sitting, and the TV would have been right where you ladies are right now, he would have been watching that. The disturbance would have come to his left and towards his front. As he is getting up to find out what that is, he is shot as he is saying, hey, hey. They're talking about how it's remarkable that he is able to walk a couple of paces. The doctor testified, absolutely, he would have had the ability to do some purposeful movement. There was no damage done to the spine that would have dropped Mr. Jean like that. He was able, because it was his intent to look and see who's coming through that apartment. He was able to take a couple of steps forward before his body failed him. That is the only explanation that fits with all of the physical evidence. The only other reasonable possibility, and I admitted this during opening statements, and I embrace it now, was Mr. Jean hiding, getting down as low as he could to get behind that small 3-foot counter because he saw her coming in with a gun. Either way, Botham Jean was never a threat to Amber Guyger. Never. Justice needs to happen in this courtroom today. For over a year, there has been injustice, indignity, and Mr. Jean and his family have waited for a year for justice. You 12 people get to write the last chapter in this story. Although there's been injustice and indignity so far, you can restore justice to this case. You can say, Botham Jean, you did nothing wrong and you did not deserve to die. By your verdict, you can also tell her, you will be held responsible for what you did. And whether or not you want to accept responsibility, it's going to be forced upon you. And by God, in Dallas County, Texas, there will be a consequence for you walking in and shooting an unarmed, defenseless man. Thank you.